My position, Your Honor, is that these pictures, first of all, should not be admissible. One, because of a discovery violation. We've never seen them before. Two, because we have reason to believe that he did not get them from Erica Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
that's a lie. I object to that.
Let the state make their argument without interruption, sir.
That's a lie, though.
Three, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom. I think that that's what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada, and for doing so, he was convicted of statutory, pled guilty in March of 2007 to that felony offense, and is a second on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
furthermore,
I object to that.
I'm not
because that's a lie.
Let him
because at
finish.
the end of the day,
Let him finish.
If we're gonna open the door on that, no, since he want to make a record and not be accurate, so let's be accurate all on the record. Since you think you know so much,
once
so
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can
loud,
open the door on how old she told me she was when we
interrupting.
met. We can ask that question
He is
too. Then
over the
Did you
top,
ask that?
animated
Did you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state finish.
No, I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be back. And unless he brings that letter and he can show it is inadmissible, she will not be questioned. And under 906.11, I will declare the cross-examination closed. Thank you. We're in recess, 1 hour.
Get your facts straight. So let's open the door on all of it then, so we can get all of it on the record. Since you think you know so much. Did you know she said she was 18 when I met her? Did you know that?
I think he was able to do it. I just don't think he wanted to. I just think this is all part of his charade. This referring to himself in the third person, trying to distract him or detract himself, I should say, from the events, taking absolutely no responsibility. It's the act of a narcissistic coward. Those words have been used here today, and nothing could be further from the truth. He is a coward. He ran like a scared little chicken from this parade, trying to slither away in the dark of night, but only to stop long enough and try and take advantage of good citizens that would help him. He calls and lies to his mom, right? Get me an Uber. I can't get into it. He lies to the officers repeatedly. We saw the time of his arrest. We heard the testimony from Daniel Ryder, a good man with good intentions and a good heart, who took this murderer into his home and held him there long enough for the police to come and take him away without any knowledge whatsoever of what had gone on. He takes advantage of everyone. He's extremely manipulative. He absolutely thinks he's in control of everything, when in fact, as he sits here in custody, he's in control of nothing except for his own behavior.
Mr. Brooks, be quiet.
Except
I'm
for
not
his...
going to sit here and be disrespected.
Mr. Brooks, be quiet.
I'm not going to sit here and be disrespected.
These are sentencing arguments and they can make them.
So I could do the same thing?
Mr. Brooks, there's nothing disrespectful. They are doing it in
Yes,
a
it is.
respectful way.
Okay, call me out of my name again.
Go ahead, Attorney Opper.
Judge, these are the facts. You heard from so many of these parents and so many of the people that were there of that fight or flight, right, that kicked in. He ran. That is the extent of his criminal history that we are aware of, Your Honor. I think it's very plain on its face. He's a lifelong criminal. He is someone who has repeatedly, continuously disobeyed law enforcement based on the resisting, obstructing type charges. There's multiple counts of bail jumping, disregarding court orders, disrespecting court orders. There's multiple acts of violence. There's weapons violations. This man has a history and a pattern of engaging in violent, dangerous behavior in the community. And it was no different on November 21 of 2021. I'm not going to spend a lot of time talking about the attack. And I choose to call it an attack instead of referring to it as the parade, as somebody mentioned. There's nothing wrong with the parade. The parade is good. The parade is the embodiment of a community. That's what you expect to see at a parade, is children at a parade, families, people from all over the area coming together for a joyful, happy event. The parade will continue. It will kick off again in a few short weeks. And I hope and pray there's joy and laughter and kids in the street collecting candy. That's what it should be. So I'm not going to refer to this case as the parade. I'm going to refer to it as what it was, an attack. And the facts are very clear, Your Honor. Very few of the victims who were struck had any idea this car was barreling down on them. It's an act of a coward, plain and simple. They had no way to know it was coming. And he mowed over them and ran them over without any ability to defend themselves. What is so offensive about this conduct, Your Honor, is obviously the violent nature of it, but even more so, the defendant's conduct and behavior in this court, his complete lack of regard for the decorum of the court, the respect of the court. And I don't mean you personally, of course you deserve that as well, but I mean for the sanctity of the court, the courtroom, the process that we as Americans respect and treasure and protect for well over 200 years, and he can't engage in the most civil behavior as being quiet when another person speaks.
Thing worth noting is the testimony of Detective Casey that this video was obtained from the defendant's own Facebook account as well. The court is well aware.
He said social media. He
nothing
didn't say what it was.
Sir, stop interrupting. We have to make a record of it. You've
Then make the record
interrupted multiple times. I've been abundantly patient with
clear.
you. Again, another interruption. So you need to be quiet and let the state make a record. Stop gesturing at
asking me to be
me.
quiet?
Stop rolling your eyes at me. Stop
I'm
mumbling.
looking right at you. I'm not rolling my eyes.
No, you
I'm
have
looking.
throughout. I've seen it
I'm
and
looking.
I've made note
I'm
of
looking
it.
at you. Okay, so are you asking me to be quiet or are you telling me to be quiet?
Go ahead, Attorney Opper.
Thank you, Your Honor.
I'm gonna take that
and
as
just
asking.
to indicate, Your Honor, this court has been abundantly patient with Mr. Brooks. He challenges the court's authority repeatedly. This court absolutely has the ability to tell him, sit down and be quiet. And you haven't done that. And I know why you haven't done that, Your Honor, and we appreciate that. He is not in control of this courtroom. You are. And he needs to respect that. This video was relevant based on his questioning of Detective Casey, as you just indicated, challenging his ability to identify the person who had their back turned to the camera in the still shot of State's Exhibit 175. Trials are fluid. When he opened the door to that, we came up with the video which Detective Casey testified repeatedly on direct examination and cross-examination as to how he knew that was Mr. Brooks, because he had seen the rest of the video. He would not accept that. He pushed it and pushed it and pushed it until we played the video. The lyrics of that video probably would have been prejudicial. Originally, I wasn't going to ask for volume. Then I did, because he pushed it again, and his voice and his mannerism of speech I thought would have assisted the jury in identifying Mr. Brooks as the person in the video with the red SUV. However, you smartly asked me to play it without the audio, and I did that, and then I never went back to that. This is all to the benefit of this defendant, who continues to suggest and impugn the integrity of this court and this prosecution without basis. He doesn't like it because the evidence is stacking up and stacking up, and whenever it does, his response is to accuse you, the court, or the prosecutors of being unethical and hiding things. There is nothing in law that prevents me from pulling something out of my briefcase right now and making it an exhibit if it's relevant. You decide what's relevant, what's admissible, not Mr. Brooks. There is no law, he can cite to no law, no authority whatsoever that says I can't make an exhibit essentially on the fly if it's called for, and that's exactly what just happened here. So I apologize for my tone with the court. I don't mean to direct this at the court. It is very frustrating. The court has demonstrated much more patience than I have with Mr. Brooks because, again, I do not appreciate his impugning the integrity of these proceedings, of Your Honor's efforts to run a fair trial, and of our efforts to run a fair trial. We have ethical obligations as well to be fair in this courtroom. We have respected that entirely. The reason I was laughing 30 seconds ago was because the exhibit was mislabeled. There was an extra Y and it said Exhibit E, EXHIBITY. And I turned around to the paralegal and pointed that out, and we laughed over it, the word exhibity. That was it. There has been no disrespect directed at Mr. Brooks directly in any fashion. So he can object all he wants, and he has made that clear. He will continue to object and obstruct the court and obstruct these proceedings every last chance he gets. But legally, everything has been above board and proper, and this exhibit is no exception. I apologize for my tone, Judge.
Thank you. I appreciate that additional record being made.
I object to that.
My previous ruling doesn't change in any way that the exhibit is relevant. I indicated I would take it up because, and I'm taking what the state's saying as withdrawing the request to play the lyrics.
That is correct.
All right. I have not heard them, but I'll certainly take the state at its word as an officer of the court that it would be prejudicial based upon the lyrics that are in that video, but my decision to admit the video without audio stands.